Good morning, everybody. Suzanne Dibble here, data protection law expert, coming to you live. I'm pretty uncut today as well, seeing as I had not much sleep last night. So lots of bags under the eyes, etc. But I am here for you for an hour to answer your Qs and give you some As. I was going to say answer your Qs and As. No, I'll answer your Qs. So welcome. Let me get this up on the iPad so that I can see your questions. Morgan, you've got in quick again. You're good at this, aren't you? Getting your question in there first. Okay, we'll just let a few more people join. Welcome to everybody. It is D-1. Well, actually, is it D-1? I guess it is, isn't it, really? Hi, Martin. He says, oh no, it's me again. It is a reassuring pleasure to see you on these Q&As every day, Martin. So thanks for joining us. So GDPR comes into force tomorrow. What a whirlwind 90 days for me it's certainly been. I don't know about you guys. I guess it depends where you join me on the journey. I know some people are literally just coming into the group yesterday. But some of you have been with me right from the start, from 90 days ago. When I started doing my videos in this group, and well, it's flown by actually, hasn't it, really, I think. And honestly, the level of the discussion that we've been having in the group and the knowledge that you guys have built up, and it's really wonderful when I see people helping other people out because of the knowledge that they've gained through this group. It's absolutely fantastic. So thank you to all of you for playing your part in making the group as great as it is. So let's get stuck into your Qs, and I'll give you some As, hopefully. We'll be on for an hour, and I'll be going through them in the order that they're showing up on my iPad. Okay, so how are we all feeling? All good? Got everything all ready? Feeling okay? Now, do remember, actually, before we start the questions, don't panic. Although saying that, I'm feeling a little bit like panicking myself right now. But yeah, don't panic. There is not, the world is not going to fall in. The sky is not going to fall in tomorrow morning. Well, I guess at 1 minute past midnight when it comes into force. And as long as you've taken a few steps towards compliance, you'll be absolutely fine. Okay. Oh, thank you. Kerry's saying I've been a legend through all. Thank you so much. Thank you. Okay, so enough preamble. Let's get into the questions. So Morgan says, hi Suzanne, if a US payment processor says they are GDPR compliant and has updated their terms and referenced GDPR and EU users in them, but isn't a member of the Privacy Shield, doesn't include model clauses in their terms and isn't providing a separate processor agreement, is it okay to use them? Well, I'm not sure what they've updated their terms to say, Morgan, but if they've not got the processor clauses in there and there isn't an extra safeguard for the transfer of data outside of the EEA, then it would sound like they're not GDPR compliant. And as we know, what GDPR says is that controllers can only use processors who are in effect compliant. So that's what the law says. Whether you choose to move away from them or not is another matter. I think that, processors, particularly those in the States, are playing a bit of catch up. This is all pretty new to them. And suddenly they're having to do lots of things to their software to make it compliant. So I think if they are making noises about working towards compliance, then I personally would decide to continue to stay with them, particularly if it was a big upheaval to my business to put a new software solution in place. If, on the other hand, they're just not answering questions properly, they're being, putting their head in the sand and not engaging in that discussion, and you can tell that they're actually really not that interested in becoming compliant, then I would look at moving away from them. Jenny says, what about contact forms on websites? If someone puts their email address and some personal and also potentially sensitive data in there, what are my responsibilities? So the first thing to say about contact forms on websites is that if someone has contacted you then you don't need their consent to then reply to that contact form. What you can't do without being upfront about it and potentially getting their consent to do it is add them to your email marketing list and start sending them marketing emails. Potentially. So it's not an assumption that you can do that. So if there's sensitive data within that, then make sure obviously you've got your privacy policy, Ginny, on your website that will deal with sensitive data. It depends what you do. I mean, if you don't expect to have sensitive data, then I wouldn't necessarily mention that in your privacy notice. But if you are doing the kind of things where people might volunteer sensitive data, then I would include that in your privacy notice. And what are your responsibilities? Well, that's a bit of a wide question, Ginny. Your responsibilities are, as it always is with processing data or processing personal data. Maybe you can ask more of a specific question about that. Verity says, hi again, Suzanne, sensitive data for a health and beauty salon. Can we, in our privacy notice, state 2 types of lawful grounds for different areas of sensitive data? E.g., medical history declared on the form and verbal info given during treatment are explicit consent, but are written observations for ongoing treatment progression care is contract law. Yes, you can do that. So it's different purposes. So yes, you can have different lawful grounds for the same information, but when you're using it for different purposes. So yes, absolutely, you can have the different lawful grounds in answer to your question, Verity. I don't collect or store any sensitive data on my website or MailChimp. However, I have a booking button which links to my online booking system where we do hold sensitive data. The one-page privacy notice declares use of sensitive data, which we usually only obtain once the client has arrived and filled in the form. Therefore, do I need to have the sensitive data section on my website privacy notice as well as the one-pager? Yes, no harm in having it there, is there? So if you're potentially getting the sensitive data through the website, then yes. Adam says, how do we fare off with DSARs when IP addresses are involved? So subject access requests, when IP addresses are involved, we don't know who those IP addresses are for, but are processed for security by a third party in the US. Don't know, Adam, is the answer. I really don't know. With a subject access request, obviously what they're doing there is finding out what personal data you're holding on them, and indeed IP addresses can be personal data. But as for the technical side of doing that, I really have no idea, so I'm sorry, can't help with that. Christopher says, hi Suzanne, love the live chats where you can ask questions. Excellent, I'm glad you enjoy them, Christopher. Here is my question for you. For suppliers in China with the standard clauses, do I need a processor agreement for the supplier and also the standard clauses, I think you're saying, or is it enough with the standard clauses? Yeah, so with the, if you're using a processor, wherever they are, then you need the processor agreement or the standalone processor terms that will go in an existing contract. Wherever they are, you need the processor terms. Now, the standard contracts, because or the standard contractual clauses or the model clauses, it's basically these pre-approved contractual terms approved by the EU that have this extra level of safeguarding when you're transferring data outside of the EEA. And there's a bit of a crossover. So the standard contractual clauses include a lot of the things that are in the processor terms, but not all of them, because they predated GDPR and the EU haven't brought them into line with GDPR. So yes, it would be a good idea, wouldn't it, if they included everything, but they don't. So at the moment, then you would have to have the processor agreement wherever the processor is in the world. But then if that processor is outside of the EEA, then you would need to have the standard contractual clauses in place. Sarah Jane, the pet whisperer. Wow, that sounds awesome what you do. One of my friends was trying to find a pet whisperer, a dog whisperer the other day. So if she hasn't found someone, I will point them your way. Sarah says, delighted to be here. Delighted to have you with us, Sarah. Thanks for joining. Lisa says, new here to me in Australia, and I haven't started yet as I've been confused by it all. Please don't get upset with me. I just find it so overwhelming. Oh no, Lisa, you've used the 2 words that are banned in my group, namely confused and overwhelming. Okay, you can either put your energy into being confused and overwhelmed, or you can start with my pinned post and work through it step by step, simply and logically. And if you invest half a day to just understand the basics, you'll start to feel a lot more calmer. Okay, main thing is to switch off all the noise out there, just work through the pinned post, and you'll feel less overwhelmed, you'll feel less confused, and you can put in place a few simple things to make, you might not be 100% GDPR compliant, but if anyone comes knocking, you'll be absolutely fine. Christopher says, we have a production in China that we send products directly to, so customers, but only name, email and delivery address. Okay, is there a question there, Christopher? Please actually ask me the question rather than making assumptions that I can guess what the question is. Sarah Jane, the Pet Whisperer, says, regarding lawful basis for sensitive data that a client offers during treatment, she's a therapist, does it need to be explicit consent or legitimate interests, as they come to me knowing they share sensitive data so they can heal and move forwards? Okay, so there's a number of videos in the group on sensitive data if this is new to you. But with sensitive data, firstly, you need to have the lawful ground of processing that you need to have for all personal data. And that's things like your consent ground, the legitimate interest ground, the contractual ground, the legal ground, etc. But then you need an extra condition for processing sensitive data. And the 2 main ones for that are explicit consent of the data subject, or there's a health ground. So if you haven't yet watched that video, just grab my book. If you haven't yet watched the video on sensitive data, then it'd probably be worth you going and having a little look at that. There's also a sensitive data ground for employment purposes. There's one for foundations, associations and not-for-profits. There's a ground for personal data which are manifestly made public by the data subject, etc. There's about 10 of them, which I'm not going to go into here, but if you go and watch the videos that I've done, you will be able to feel a lot more confident about how to deal with sensitive data. So if you're just getting sensitive data from a client during a treatment, then if it is data that you need in order to fulfill the contract, then the first bit of that is contractual. The second bit of that is their explicit consent, and if they're giving that orally to you, oral consent is fine. You just need to keep a record of the consent. So I'd have probably you do consultation notes after the event. I'd just make a little note to say, they gave me this sensitive data and they've consented by looking at the privacy. So you'd give them the privacy policy and at their first point of consultation. If they're not entering any information through your website, you'd give them the 1-page privacy notice that I've put together that's in my pack. You'd give them that. That tells them that you're going to be using that sensitive data. They sign that form. That's the explicit consent that you need. Okay, so it's better to do, actually much better to do that than have the oral consent. But if there is, just so that you know, if there is an issue where you can't get them to sign anything, then in theory, oral consent is fine. So Natalie says, morning, I have a question, but I'm the owner of a small recruitment consultancy, just her working from home. When engaging with candidates that are looking for work, I normally send them via email my engagement form, which they either sign and scan back or reply back to my email to say that they're happy for me to represent them as an agency. I don't tend to meet my candidates apart from using Skype or FaceTime unless it's necessary. Moving forward, what's the best way to obtain their consent to represent them? Is an email reply from them still okay, or do I need to scan the form with their signature back to me? I'm using Wix's website and I can't seem to find a tick box option for my contact form. Yeah, so the GDPR talks about an affirmative action in order to give that consent. It doesn't actually say that you need to have tick boxes. Now, obviously, tick boxes are one way of obtaining that consent. But the definition of consent is a freely given, specific, informed and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data. So yes, if you've sent them they've had your privacy policy somehow, and they know what you're doing with their data, and then they consent to the various elements of the processing that you've decided need consent, then yes, and the act of them sending you an email would be that affirmative action. Kathy says, can marketing emails be sent to personal email addresses within a limited company email system? Okay, so there's two things here with sending email marketing. One is GDPR, obviously, where personal data is involved. But remember, personal data is data that enables you to identify a living individual. So if the email address was just info@123limited.com, obviously you couldn't identify an individual from that email address. Now, if you had other bits of data as well around that email address and you could put them together to identify an individual, then that would potentially bring it into the remit of personal data. But if you have an email address and it is, Peter Jones at 123limitedcompany.com, then, if there's only one Peter Jones at that organisation, then that is personal data. So then you need to think about what is your lawful ground of processing. And typically, if you are emailing B2B, then legitimate interests for GDPR purposes will be appropriate. Okay, so you wouldn't need consent under GDPR. However, the other regulation at work here is PECR, and this at the moment only applies to businesses that are established within the EU, although it's likely to be extended to businesses have the same scope as GDPR next year when it's revised. But with PECR, what that says is that you can't send a unsolicited email marketing or text to individuals, and individuals include sole traders and partnerships. But you can, under PECR, you can send emails to corporates, so limited companies, LLCs, things like that. So the answer, I think, Kathy, is yes, you can send marketing emails to personal email addresses within a limited company, but you need to make sure that you've got that lawful ground of processing under GDPR, which, as I say, for B2B emails, then is likely to be legitimate interest. So what you need to do, make sure in your privacy notice you are stating that, and you are referring to the legitimate interest ground and explaining what that legitimate interest ground is, which is marketing in order to grow your business. That's your legitimate interest. Okay, Ina says, hi Suzanne, thank you for all your help. Thank you, Ina, you are tremendously welcome. I have a question about sensitive data, specifically health data. Due to my close relationships with my clients, they notify when they're ill or tell me other health information. I've never requested that info, nor do I need it. I receive it via email or Facebook Messenger, but the information is bundled up with the rest of the data that I need to keep for various reasons. Do I need to put the sensitive data section in my privacy notice? It can't hurt, really. And as long as you're saying, the sensitive data that we're processing is where you've sent us sensitive data, then that is that's fine. It's about being upfront about that. Now, for the health data, it depends what you do, but there is, for the special condition for processing the sensitive data, the actual extra condition is the processing is necessary for the purposes of preventative or occupational medicine, the provision of health or social care or treatment, etc., blah, blah. So the health ground is actually, when you look at it, and particularly when you look at it in the Data Protection Bill, which is going to be enforced in the UK, it is quite a restricted ground for registered health professionals, and it's not... I personally don't think that many therapists would be covered by that ground. So you would be looking at explicit consent to the processing of the data, and or potentially where processing relates to personal data which are made manifestly made public by the data subject. So if somebody is coming into a Facebook group, for example, and posting sensitive data, then, obviously you don't need to have got their consent beforehand to do that because they've manifestly made that public. With the it's a very interesting question actually, because what if people are just sending it to you, you do need that extra condition, but then how do you build that into your processes in order to get that condition? If, like you say, it's bundled up with other information and you can't just delete it. I think that, in terms of what is that explicit consent, examples that have been given as to how we get that explicit consent are either a signature on a form or a double opt-in process. So I think, if you are in an industry where you're likely to be getting sensitive data, then it might be a good idea to start thinking about putting in place double opt-ins for your, when you take on a new client, you're sending them the privacy policy and you're getting that email back to say, yes, that is, I'm fine for the sensitive data to be processed. But it's an interesting area, and I'm sure we'll see it develop. Okay, Ginny says, what I meant by responsibilities was if someone discloses personal and sensitive data to me via a contact form, what am I obliged to do with that data? Simply to keep it safe. I don't intend to add them to a mailing list. Well, what are you obliged to do with the data? Well, if you don't need it for anything, I guess you've got the same issue, Ginny, haven't you? That sensitive data might be mixed up with other data that you do need to keep. So yes, I think absolutely keep it safe. And again, the same issues apply to you, Ginny, as we've just been talking about. And anyone who potentially is receiving sensitive data, if you're not actually requesting that data, but people are volunteering it, how does that actually work? And the answer is, I really don't know. I don't know in practice how that's going to work, but that's certainly something that we'll keep our eye on. And that's the kind of thing that this group going forwards will be looking at, how this is all playing out in actual practice. Okay, so Catherine says, hi Suzanne, I've bought your pack and it's been great, thank you. Brilliant, good, glad you are finding it useful. We have a video production company. I've never done email marketing. We have lots of video footage from clients which we keep alongside their details. We've always kept it in case they want to have footage re-edited in the future. Should we be emailing old clients through our new privacy policy? Yes, so in theory, we should all be emailing our clients our new privacy policy. However, I think if you were to email it them as part of your next communication to them, that would be absolutely fine. We are thinking we may need to get rid of old footage after informing old clients. Also, do you think we now need to have a notice up when we are filming, or would the same apply to photographers, that there is a reasonable expectation that people would be filmed? Yes. So in terms of in terms of thinking about needing to get rid of old footage, then yes, if it's personal data, if you no longer need that data, then the data minimization principle applies, and we should only hold data that we actually need. So if it is redundant, if you're keeping it for a just in case, then probably a good opportunity to have a clean up and delete that footage, to the extent that it's personal data. Do you think we need to have a notice up when we're filming, or would the same apply to photographers, that there is a reasonable expectation that people would be filmed? I think that depends on the context, but if you want to put matters beyond doubt, then I would have a notice. Sorry, I can't be more helpful on that. Okay, so Camellia, what a lovely name. Gosh, we do get people with lovely names on these Facebook Lives. I think I might change mine. Mine's so unexotic. Camellia Stoian. How wonderful. You sound like you're an actress or something, Camellia. Hi, Suzanne. What about software we use in order to manage restaurant orders? We store name, phone numbers and addresses. they say that GDPR does not apply in their case. Okay, maybe they're the one special company that it doesn't apply to. But I don't agree, since they will connect remotely to update the software. So they have access to all the data in there. Yes, absolutely. So remember, the definition of processing is really wide, including making available. So yes, if you have a processor who in theory can access the data, then we need to make sure that they're GDPR compliant. And yes, you should have that processor agreement in place. Good luck with that, Camellia. I know it's tricky when organisations are saying that GDPR doesn't apply. Patty says, hi, I'm a small not-for-profit mental health charitable organisation, and I would like to know, at this stage, is it better to register as not compliant at the moment? Okay, so registration is a completely different thing to being GDPR compliant. What we have at the moment is a system of registration where businesses were saying, here's how we process our data. That is being phased out. What's coming in is internal accountability, record keeping, privacy by design and by default. And the current registration charge is moving to what I call a controller charge. Rather than it being £35, it's going to be £40. And chances are that if the ICO current registration fee applies to you, then you'll have to pay the controller charge. Now, if you are already registered, you have, you pay on an annual basis. So if you registered 6 months ago and you've got 6 months left to run, then on the expiry of the current ICO registration fee, then you will migrate onto the controller charge. Okay, so don't worry, Patty, you don't have to suddenly rush and register with the ICO today. To be honest, their website is probably down, I would have thought, because of the volume of traffic. So don't panic about that. Keep an eye out in this group for more details about the controller charge. And I'm sure what the ICO will do is amend their online assessment that basically asks you a series of questions, and then at the end of it tells you whether you need to register. That will, I'm sure, be adapted for the new controller charge so that businesses can go onto the ICO website and work out whether they need to pay the controller charge or not. Sarah Jane, the Pet Whisperer, says, I also work with animals and clients. Oh no, I also work with animals, pause, and clients will complete an online referral form disclosing their animals' health and behavioural issues. I know GDPR doesn't apply to animals, but sometimes people will share sensitive data about themselves on the referral form in the context of it possibly impact on the animal's health well-being, e.g. alcohol use and disability. How do I stand with that? Yeah, well, if you are processing that sensitive data in relation to a person, then yes, that brings you into the realms of sensitive data, and the conversation that we were having before would apply to you too. Christopher says, thank you very much, Suzanne, for your help. You're very welcome, Christopher. Where are you from, Christopher, with a name like Christopher Frostholm? Are you from one of our Scandinavian friends? Carlo says, hi Suzanne, thanks so much for all your help. You are exceptionally welcome, Carlo. Thank you for your kind words. My lead magnet also includes a promotional offer. They come together. Can I request consent for both of them at the same time? Yes, the age-old question of can you bundle lead magnets with advertising emails? Now, I think that now let's say, to put this beyond doubt, what you should be doing with your lead magnets is you have get your amazing free report here, put your email address in, and you would have a tick box underneath that says, if you want to receive details of our discounts, promos, whatever else, click here. And you would have that granular tick box for marketing emails. Now, some software just won't allow you to do that at the moment. Others, people are concerned about it really cutting down the conversions in terms of people not ticking that box. So what can we do? So what you can do, Carlo, is you can say, if you had a newsletter and that provided that included all different kinds of things, that would be value-based emails and occasionally relevant promotional offers, etc. And then what you could do is you could have a sign-up box for the newsletter, and as a thank you, you could send them the amazing free report. So I think that you could definitely, just noticed my hair's all a bit strange there. You could definitely switch it that way if you are having problems with tick boxes. So you could say, sign up for my newsletter, which includes amazing value-based articles, blah, 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 but also the occasional offer and promotion. And when you do that, receive X amazing free lead magnet. So I think you could definitely do that. But yes, if you are just bundling them, saying here's the amazing free report, and then you don't specify the fact that you're going to send them offers, and you do, then in theory people could complain about that. So if you really can't get away from the bundling, just be as upfront as you possibly can about it. So you would say, get the amazing free report, and then we're going to tell you about how you can take this forward with us, or something like that. So the more upfront that you can be in terms of what you're actually going to be doing with their data, the better. But to put it beyond doubt, having that separate tick box underneath the lead magnet that says, tick here if you'd like us to send you details of our offers and promotions, that's the safest route, okay? Ian says, can we still send a re-engagement email out after the 25th of May? No. The issue is that if you've decided that you need to get fresh consent because you don't have a GDPR standard of consent, then after the 25th of May, if consent is the only lawful ground that you have for processing that data, then you don't have a lawful ground of processing after tomorrow. And in effect, you are illegally processing that data. If you haven't had any consent at all, then sending them a re-consent email is illegal in itself, and companies have been fined for doing that. But no, you need to send, if you've decided that you have got consent, but it's just not to a GDPR standard of consent, and you can't rely on legitimate interests or another lawful ground of processing, then you would need to obtain that GDPR standard of consent before the 25th of May. Now, what you could potentially do is, so we know that we can't send marketing emails out after, if consent is your ground for sending marketing emails and you don't have a GDPR standard of consent before the 25th of May, then you shouldn't send marketing emails, okay? Now, what I think could potentially be okay, and you need to obviously weigh up the risk analysis of this, because it's not at all beyond doubt. There's question marks over whether this would be okay. But potentially, if they have agreed that you can send them value-based emails, okay, or you can potentially say there's legitimate interests in you sending them value-based emails, then possibly as a PS at the bottom of that, you could say, click here to receive details of our offers or services. And certainly I think you could still say to people, sign up here to receive our newsletter. And if you're really upfront about what's in your newsletter, and that includes other value-based items, but also offers and promotions from time to time, and people at that point consent to it, then that might be one way around it. But as I say, it's not 100% that is, that's all fine. It's a grey area. Certainly what you can't do is after, if consent is your lawful ground of processing and you don't have that to a GDPR standard after tomorrow, you can't send them a full-on marketing email, okay? Now, my question, and what I would argue, is that if you're sending them a really value-packed email, it's not a marketing email in itself, and there's a PS which has got an offer which is very, very relevant to the content that you've been talking about, or it's a question mark, would you like to sign up to my newsletter, which includes details of offers and promotions, etc. That might be a way around it, okay? But that is not tested. That's just me thinking of potential ways if people, because so many people will miss, the 25th of May, of course. So yeah, I think that's one way to look at it, and I'll be keeping an eye on this, and this is the kind of thing that we'll be talking about in the group going forwards. Okay, Emma says, is there going to be a retention policy added to the pack rather than a checklist that's there at the moment? Yes, it has been here on my desk all week, and I just need to give it a final once over. I can't find it now, but it is literally here. And there aren't enough hours in the day, quite frankly. But this, it's not something that you imperatively need by tomorrow. But it will be there as soon as possible. Okay, Natalia says, thanks for all your help. You're very welcome. If you copy and paste emails from Facebook group questions into MailChimp, is it enough that they've given you consent via Facebook? I clearly state what the email is for and that they can unsubscribe, and it's also a double opt-in. I don't have Arnie's tool yet, obviously. Yeah, Arnie's tool has saved us months of work with that tool. But yes, if you're copy and pasting into MailChimp and if you've said in that Facebook question, so for those of you who don't understand what this is about, if you've got a Facebook group, you can ask people questions when they come into the group. It's a way of keeping out spammers, but often people will ask if people want to receive something, typically an item of value, and ask for their email address. Now, obviously, that is the consent for you sending that thing that you've told them about. So in my instance, I say, give me your email address if you want to receive my free checklist, and people give me their email address and I send them that checklist. So again, I think what you can do there is you can't then just post GDPR assume that those people also want marketing emails. But I certainly think that in sending them that checklist, you could say, click here if you'd like to sign up for my newsletter. And that newsletter, like I've just said, you would state what's in that newsletter, and that could potentially include marketing, details of your offers and promotions. So yes, in answer to your question, Natalia, I think it's consent enough to send them the thing that you've told them that you're going to send, and then you need to think a little bit more carefully about if you want to send marketing emails going forwards, what's the process for that? Carolyn says, hi, I'm a sole trader photographer and I've sorted out my privacy policy and website notice, sorted secure storage, etc. I don't send marketing emails. I've only ever contacted people regarding their bookings. I'm just not sure if I need to email all previous and current clients with a link to my privacy policy or just put a note of this on emails going forwards. Yes, GDPR doesn't actually say when it comes into force, you must email all the people that you hold data on your new privacy policy. What it says is that where personal data relating to a data subject are collected from the data subject, the controller shall, at the time when personal data are obtained, provide the data subject with all of the following information. Now, if you collect it from that data from somebody else, then the obligation is to, within a reasonable period after obtaining the personal data, but at least at the latest within 1 month, having regard to the specific circumstances. So going forward, as if you collect data from somebody else, you have to give the privacy policy to the data subject within a month of that data being processed. If the personal data are to be used for communication with the data subject, at the latest, at the time of the first communication to that data subject. Blah, blah, blah. So that's going forwards. So, in my view, obviously lots of big businesses are sending out their new privacy policies this week. But, if you send it as a PS to the next email communication that you send out, then, in my view, that's going to be absolutely fine. So, but then going forwards, obviously you need to be careful that you are giving the privacy notice at the point of collection of the data, or if you're collecting it from a third party within a month, and at least on the first communication to that data subject. Natalia says, do I need to resend updated contracts to my coaching clients? What's the key thing that needs to be there? Privacy policy and consent. Yes, so you don't need to update your contracts necessarily. I'd have a look through them just to check what they're saying about data protection, but typically all they'll say is the parties will comply with data protection laws. The documents that you need to update are your privacy notice and your cookie policy, and you can get hold of those from, they're in my pack, so you could go and check that out. The link for that is in the pinned post. And really that's the same question, isn't it, Natalia, that we've just talked about. Richard says, we're a small advertising company. We have online inquiry and direct through the landline. We store no data other than individual contacts for use directly, no large mailing list or group mails. Website collects no cookies. What do we need to change to be compliant? Okay, I can't answer those very general questions, Richard. What I suggest you do, if you haven't already, is go and watch the overview training, get hold of the checklist and work out what applies to you. I also did a video for very small businesses, which, not that I'm saying yours is a small business, but it sounds like you're doing the minimum with your data. So you might want to go to the file section and look at the list of videos that I've done and find the link for that. It's called, I think, GDPR and Very Small Businesses, I think, something like that. Maya, M-Y-R, lovely name, but I'm not sure how to pronounce it. Thanks for these Q&As, Suzanne. I have a question. If I have a landing page where I ask people to purchase a workshop for $97, do I need to have the same approach as with an opt-in page? Or is it enough just to have terms of use and a privacy policy below the buy button? Yeah, so if people are buying things from you, and particularly if you're saying $97 there, so I don't know if that means that you're in the States, but certainly if you have existing customers, which they will be if they've bought a workshop for $97, then if you want to send follow-up marketing emails to those people, chances are you could rely on legitimate interests and you wouldn't need a consent tick box under that form. The PECR doesn't apply to people outside of the EU at the moment, but certainly with the PECR, even if it does, if you're in the EU, then for existing customers, as long as you, at the point that you're collecting the information, inform them of their right to unsubscribe and link to the privacy policy, then you'll be able to market to them in accordance with the soft opt-in. Okay, so yes, have terms of use, yes, have a link to your privacy policy, but also have a statement that says you may opt out at any time. Okay. Hi Suzanne, I'm sorry if you've already answered this question, but when is it enough to just send the privacy policy to subscribers on my list rather than getting them to resubscribe? I work with entrepreneurs. The service I offer has not changed from when they signed up, as my business has always been the same. I have asked people to resubscribe, but now I'm thinking sending my privacy policy will be enough. Okay, so if you haven't already seen it, Emma, then go and have a look at the reconsent checklist that's in the files section of the Facebook group. But it's a complex area, but you need to look at your lawful ground of processing and whether you can rely on legitimate interests or whether you actually need consent. Now, with customers, they have a proximate relationship with you. They might reasonably expect to receive marketing emails from you. I would be comfortable for GDPR purposes to rely on legitimate interests for that. As I say, you also need to think about PECR, which says you can't send unsolicited marketing emails to individuals. So if you've got individuals on your list, then if they are customers and you're marketing to them about something similar and you gave them the right to opt out at the point that you collected their details and you've done that on each subsequent email, then the soft opt-in will apply, and for PECR purposes, you wouldn't need consent. So fairly complex area, but yes, if you don't need to obtain a new standard of consent, then all you need to do is send them your privacy policy and advise them of their right to opt out of that. But go and take a look at that reconsent checklist in the files section. Sarah Jane, the pet whisperer, either you're very quick with your questions or there is an algorithm on my iPad here that puts your questions before everybody else. but another one's popped up. Okay, each time I learn something new, I have more questions. Yeah, that's the way it works. Does anything need to be done for clients or prospects who send sensitive data to me in an email on my email system? Yeah, okay, I think we've done that topic. Natalia, gosh, I think the same for you, Natalia. This is like fourth question. I'm about to send one of the resubscribe emails for one of my lists. Do I need to create a new list for them to subscribe to, or do they just get updated on that list and then I delete anyone who didn't opt in? Confused. Okay. There's one of the banned words. So we're not using the words. Remember, no confused, no overwhelmed, and we'll be just fine. But Natalia, it depends. I think that's more of a technical question about how your email provider works. So if it's MailChimp, we have a brilliant MailChimp expert in the group who can answer those questions. Also worth having a search in the group for that, because we've covered this lots of times in there. Cassandra says, a couple of last minute privacy policy questions for health practitioners re sensitive data. I fall under 9.2. Should I mention this in the sensitive data section of my privacy policy? See, 9.2. Okay, so that's the employment ground. So necessary for the purposes of carrying out the obligations and exercising specific rights of the controller or the data subject in the field of employment and social security. Yes, you can mention that in your privacy policy. Also, should I also state the bodies I am a member of in that section or elsewhere? Yes, absolutely. That would be the appropriate section to do it. Zach says, my business involves people signing up and paying for a service that is sent out via email daily. If my clients are paying for a service that requires them to receive these emails, where do I stand? Do I need to ask them to opt in even though they have paid for this service? So Zach, what you need to understand is that consent is just one of the lawful grounds of processing. There's 6 lawful grounds of processing. Consent is just one, although it is the one that everyone seems to get hung up on. There are 6 others, and the one that is relevant to you is that processing is necessary for the performance of a contract to which the data party is subject. So you don't need to get any opt-in for that. Where you're processing data in order to fulfil a contract, then no consent necessary. You need to update your privacy policy and inform people of that, but no consent necessary. Richard says, hi, automated decision taking clause in the PAC privacy policy. I suspect WordFence security plugin for WordPress does this. However, users of the plugin might not realise it. I was about to remove it from my template, but then decided not to remove it. Okay, so the thing about automated decision making is that it's only automated decision making that has a legal effect or a similarly significant effect that is relevant. So if you're just talking about things like tagging on Infusionsoft and things like that, then that's not what automated decision making is for the purposes of GDPR. So let me just find the exact words here. I've got so many tags on my book here that I can't ever find the actual sections now. Right, so it's Article 22. It says the data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her or similarly significantly affects him or her. Okay, so if there's no legal effect or it's no other similarly significant effect, then it's absolutely fine. And then even if you do have it so that there's a legal effect or a similarly significant effect, it will not apply if it's necessary for entering into or performance of a contract between the data subject and the data controller, if it's authorised by member state law, and if it's based on the data subject's explicit consent. If it's necessary for the performance of a contract, or if it's based on consent, then the data controller has to implement suitable measures to safeguard the data subject's rights and freedoms, at least the right to obtain human intervention on the part of the controller, to express his or her point of view and to contest the decision. Okay, so the majority of us in email marketing won't be this won't apply to. Really, I think people who have a number of employees, this might be relevant to, because if you're using automated decision making for maybe filtering out CVs, or in a redundancy process or something like that, then that obviously will have a legal effect, or a similarly significant effect. So that's the key thing to think about. If it's automated processing, it needs to be producing a legal effect or a similarly significant effect in order for us to worry about it for the purposes of GDPR. So Jen says, if you ask for people to consent to a weekly email and any other emails I think you will like, including marketing emails, is that adequate? Or do I have to have them opt in separately for marketing and a newsletter? I was kind of thinking, if they have to agree to both, then I can send my weekly newsletter and then odd extra affiliate things, etc. Literally once in a while. I'm not talking weekly or anything. Yeah, so as I said before, to put matters absolutely beyond doubt, then you would have a granular tick box where you are specifically asking for consent for marketing emails. Now, arguably, if it's a newsletter and it's bundled in, then I think as long as you are transparent about what that newsletter includes, then you should be fine. Okay, I say should be. There's so many grey areas. As I say, if you're risk averse, then the best thing to do is you have your separate tick box for marketing emails. That puts it absolutely beyond doubt. But ultimately, I think if you are being upfront about what you're doing with people's emails, you're respecting them, you're not spamming them, you're really delivering value. And let's face it, if people are consuming your content, it's because they want help with what you're helping them with. And then, the natural next step is, do you want our help? And here's an amazing offer, etc. As long as we're being respectful and not spamming them. Okay, Claire says, I'm a small charity. We get referrals from health professionals with their contact details on, but no details for the families we supply items to. Do I need to send an email out about opt-in or opt-out? Okay, so you're processing data about the health professionals. I think you're saying you're not getting details for the families that you supply items to. Is that because you're supplying the items via the health professionals, maybe? So if you're not actually processing the data, personal data of the families that you are helping, then you don't need to send them anything because you're not processing their personal data. If you are processing the data of the health professionals, then in theory you should be sending them a privacy policy and telling them how you're using their data. And do you need to send an email about opt-in or opt-out? I suspect you're not sending marketing emails to those health professionals, are you? So you would just need to say, here's our privacy policy. If you, and then you would say what's your lawful ground of that processing, and it would probably be, contract or legitimate interests. You would tell them that, and you would say, if it's legitimate interest, they have the right to object. But I think, Claire, in reality, if you're a small charity and you've only processing the data of health professionals, then, it's yes, the letter of the law is that you need to send them a privacy policy. But in reality, if you don't, what's going to happen? Okay, Adam says, hi, Suzanne, what do we do if somebody files a subject access request and it emerges we hold no personal data on them? Can we verbally tell them this, or do we need to put it in writing? I would put it in writing. Jonathan David Lease says, I know I know this might not be relevant to the video, but I've ordered the GDPR pack and haven't received the login. Okay, I had a number of people email me last night. I was replying to them at 2 a.m. They said, help, we ordered the pack today. We haven't received it yet. I log into my system and see that the emails were sent straight away. So please do go and check your spam and your trash folders if you haven't yet received it. The only way that you won't be receiving that pack straight away is if our team have done a manual invoice for you because the order failed for some reason. So if it was processed online and you haven't received the pack, then go and look for an email in your spam and your trash folders, because chances are it's going to be in there. It gets sent out automatically. Okay, as I say, if you're payment didn't go through the online system and our team sent you a manual invoice, then we go through payments we've received on a daily basis, and there's a little bit more of a delay there in getting the pack to you. But if it was online, go and check your spam and your trash folders. Sarah says, I've photos of people going back 4 years that I consider art and would like to keep forever. I'm not even sure how to contact some people in the photos. Do I need to delete them? So I just read something recently, actually, that there is an exemption for artistic works for photographs. In that case, you wouldn't need to delete them. So I'll actually put, it was a really good article the way it was written. So let me just make a note of that. I'm running out of space. The artistic works exemption. GDPR just is the topic that keeps on giving, isn't it? Just when you think you've covered absolutely everything about it, another really interesting question comes up. Okay, Ina says, hi Suzanne, thank you for explaining about the sensitive data when not requesting it. I'm a virtual assistant and I don't regularly collect or process sensitive data. I will include it in my privacy notice to cover myself and talk about it with clients to make sure they know I might have to keep it for some time because it's bundled with other information. Okay, great. Jane says, we have CCTV in our shop. Do you need to say how long it is kept? As if so, this seems to give information to those that may commit offences. Can you advise? Jane, I did a video on CCTV and I don't believe there is anything that says how long you have to keep it. The general principle with keeping data is you keep it as long as you need it. If for insurance purposes you need to keep it for a certain period of time, or for legal reasons you need to keep it, then you need to keep it for that length of time. Natalie says, thank you for your answer, Suzanne. You and your GDPR pack have been a massive help. Thank you, Natalie. It is kind words like that keep me going. Thank you. Sarah says, wonderful support. Thank you for your kind words. Anne says, what if a company refuses to accept they need to be GDPR compliant and are based in the UK? I know of at least 2 who are burying their heads in the sand. Okay, so if it's just a business pal and they're burying their head in the sand, then good luck to them, okay? Not worth trying to persuade people, in my view. Now, if they are a processor of yours, however, that's a different matter, because as a data controller, we have an obligation to only use processors who are in effect GDPR compliant. So if the processors are sticking their head in the sand, then we need to move to a new processor. That's simple. Catty says, good afternoon. For French people not living in the EU, does your pack apply? And if yes, are you offering a translated version or do we need to? So my pack will help anybody become GDPR compliant. What it obviously doesn't do is provide for every single other law of every jurisdiction that might impact on data protection. So it absolutely helps you to comply with GDPR. Am I offering a translated version? Nope. You can do that. And use it within your own business. Obviously, you couldn't just decide to start selling a French version of my pack, but you can, by all means, translate it. Nick says, I have to give a big shout out to Nick Sanders because he has been an absolute legend over the past few months in my group. He has answered loads of your questions. He has flagged inappropriate posts to me like an absolute trooper. He has been my absolute eyes and ears in the group. So massive thanks to Nick Sanders for being such a super helpful member of the group. And he was up for, if our GDPR party had gone ahead, it's actually now migrated into a curry night, which actually I'm quite happy about now that we're actually here. The prospect of organising a massive party with the last minute stuff that I'm having to deal with for my clients is... what was I thinking? So we've got a nice quiet curry night instead, which is brilliant. But Nick Sanders was absolutely my nomination for the award for the most helpful member in the group. So thanks, Nick. Right, Nick, he says, Apple isn't on the EU-US Privacy Shield. Any guidance on large companies like this that aren't and don't seem to have much info about GDPR? I haven't looked into Apple actually, so that's, and although I did see there was a couple of posts, wasn't there, the other day about it. So what have they done then, Nick? Have they done nothing at all in terms of this? Have they not put in place addendums or amended their terms? I'm going to have to write that down as well, because that has piqued my curiosity. Apple. Okay, more on that, Nick. I'll take that offline and look into that. Susan says, good morning. Should we be deleting client emails frequently, or must we keep these for a certain number of years? So yes, so with the data minimization principle, we only need to keep the data that we need and delete it when we no longer need it. So with client emails, the main thing to think about is contractual claims going forwards. So the period of limitations, certainly in the UK, is 6 years, which means that someone has 6 years from the event giving rise to the claim in which to bring a claim. So I would certainly be keeping client emails for that period of time, just so that if there is ever a dispute, you can go back through that chain of emails and work out what's gone on. So yeah, I would keep them. Sarah Jane says, thanks, Suzanne. Your help and dedication to the cause is second to none. Thank you. I am dedicated, so thank you. Really appreciate all you're doing to support us. Thank you for your kind words, Sarah Jane. Cliff says, where do tools such as LinkedIn Sales Navigator fit with GDPR that are used to identify and generate potential leads? I don't use LinkedIn Sales Navigator, so I don't know exactly, but what I would have hoped is that they are bringing that up to speed with GDPR, and that when people are signing up with LinkedIn, that LinkedIn are obtaining the appropriate consents, or they have the other lawful ground of processing. So remember, whilst data stays on the platform, it's the responsibility of LinkedIn. It's when you take it off that platform that you need to start thinking about what's your lawful ground of processing, and giving the privacy policy, etc. Ian says, thanks, Suzanne, your pack has been really useful. Thanks for all your help. Thank you so much, Ian. Emma says, sorry to be a pest. Never. No one's a pest. I just won't have the words overwhelmed and confused, because we can either be overwhelmed or confused, or we can just be at the start of our knowledge journey and working towards understanding what GDPR is all about, and put a positive slant on it. And she says, your help and templates have been invaluable for me. Thank you, Emma. I'm so pleased to hear that. Verity says, are you going to add a controller-to-controller agreement to the pack? Yes, it is on the list, but obviously these things take time, so it is going to be in a few weeks. And I will do that without extra charge. Carlo says, are we supposed to keep a record of all of our opt-outs? If yes, what data should we keep? Yes, keep a suppression list, and yeah, that'll be the name and the email address and the date that they opted out. Daniela Voss says, thanks for all your help. Although GDPR should be a European regulation, there are countries who handle it more strict than others and interpret the regulations in a different way. If you have clients all over Europe, how will you ever be able to comply? What do you think is the best way forward? Do you comply with the interpretation of the country where your business is based? It's a really, really good question, Daniela, actually. And the answer is we don't know how it's going to be interpreted. Certainly the German authorities are a lot stricter on things than the UK authorities. With regard to the cookie consent that came in 2013, the ICO effectively watered down the cookie consent, so that implied consent for using cookies was okay, and whereas the rest of the European authorities didn't favour that approach. And arguably, if you are putting cookies on users in the EU's, you're using cookies with users in the EU, then arguably, yes, implied consent would not be sufficient, and you would need that cookie pop-up and the person clicking on that pop-up. So yes, it's a really good question, and one that I really actually don't know the answer to. I think that certainly where your business is based, look to those the guidelines from that supervisory authority as a starting point. But great question. Right, time check. Oh my goodness, 12:30. How do these Q&As seem to go so quickly? I thought we were literally like half an hour into it. It's incredible, isn't it? Okay, so that is, I think we're going to have to stop there because I've got a ton to do today. Not least, send out my own GDPR email, which I have literally been tossing and turning about. Yes, you know, my plans of having this huge re-engagement campaign and using it as a great opportunity to tidy up my list. Well, I just got really busy helping everybody else with their GDPR. So my all singing, all dancing re-engagement campaign hasn't actually happened. So now I've got the prospect of, you know, I think something like, well, we've got, I don't know, like 35,000 people have signed up to my list in the past since I started doing my videos. And now I'm thinking, oh my goodness, what do I actually do with them? So yeah, I share today guys, I share your pain because yeah, it's not easy, is it, to decide what to do. So so watch this space. Okay, so I think we will leave it there. I know there's lots more questions. Thank you for all of your kind words. I will try to do a Facebook Live tomorrow. I've got to drive up to Oxfordshire. I've just seen a note saying that Radio 5 Live want to speak to me at, I think that was 4:45 today. So listen to that, guys. And I was speaking to Talk Radio earlier this morning, LBC last night. So it's great actually that, ideally in their studio in Guildford. Don't think that's going to happen. I think I'll be phoning in from the comfort of my own office. I will try to squeeze in a live tomorrow, although it might be tricky because of what I've got on. But I'll try to. And, you know, remember, you know, it's not the end tomorrow. It is really the start. I think the only thing that we do really need to give urgent attention to is the reconsent email if we need to do that. That's the number one priority, and getting your privacy policy sorted out if you haven't already done that. Do go and check out my pack. The details are in the pinned post. You can get the privacy policy and the cookie policy from there. You need to do the data inventory first in order to do your privacy policy. That's also in there. So that's the kind of urgent stuff. And then going forwards, then it's a case of putting in place systems and procedures. So, for example, what happens if you get a subject access request? Well, happily, there is the documents that you need for that in my pack. But obviously, I think going forwards, that's the kind of thing that we're going to be talking a lot more about. And obviously also looking at what other people are what other businesses are doing, what's the response from the regulatory authorities, how is enforcement progressing, etc. So it's going to be really interesting to see over the next year, really, how this all pans out. And then, of course, we've got the fact that PECR is being changed next year, which will, that will change things up again. So it's a really interesting time for data protection. And, as I've always said, I think that businesses that are at the forefront of this are going to have a competitive advantage. So well done you all for being in my group and being at the forefront of this and having that competitive advantage and actually understanding about it when your clients say to you, what's all this GDPR stuff about? And you'll be able to say exactly what it's all about and how you protect their data. So goodbye for now. Good luck with today, whatever you're up to. And I will, I'm sure, be doing something tomorrow. It might not be a full hour long Facebook Live, but I'll certainly be, we will be marking the occasion in some way. And for those of you who I'm seeing for a curry tonight, looking forward to that. Take care, everyone. I'll see you soon.